Kia ora, noma ki te whare. Welcome to The House. Ko Louis Collins at home. Imagine a scenario where a court rules that the government has been acting unlawfully for years. In response, Parliament passes a law to ensure the government can continue the same practice and applies that change to the past as well as the future. Well, that is in effect what happened this week.
I move that urgency be accorded the introduction and first reading and referral to Select Committee of the Social Security Accident Compensation and Calculation of Weekly Income Amendment Bill.
In a nutshell, people waiting for ACC cover often receive welfare support from the Ministry of Social Development. When ACC provides a backdated payment, it reimburses MSD for the main benefit paid out during that time. But MSD has also required individuals to repay any supplementary assistance they received during that same backdated period. A recent High Court ruling found that this long-standing policy of reassessing supplementary assistance after a backdated ACC payment was not supported by existing legislation. Here's the Minister in charge, Louise Upston.
The key thing here is this change upholds a policy that's always been in place to allocate income against the period it best represents, so that a person's income can continue to be charged accurately against their entitlement. This is an important amendment to ensure that when assessing a person's entitlement to supplementary assistance, MSD maintains equitable treatment between people receiving ACC payments at the time they earn it compared to payments earned for a past period, i.e. a backdating. Mr Speaker, this bill introduces an amendment that has retrospective effect to ensure the policy intent is maintained for both past and prospective cases.
At this point, you may be thinking, wait, Parliament can do that? Of course, one of the foundational principles of legislation is that it operates prospectively. People should know the rules before they act. Retrospective lawmaking reverses that principle by altering the legal consequences of past conduct. For that reason, governments tend to use it sparingly. In the rare cases that it is used, though, politicians across the spectrum have warned about straying down a slippery slope to a reality in which no legal coverage is certain. Here is Chris Bishop in 2021 speaking during the first reading of a Labour government bill that had retrospective elements.
And this is retrospective legislation. That's the other point, is I'm telling you now, there are going to be potentially learned law professors and other scholars who are interested in this stuff who are going to turn up and castigate the government for the retrospectivity, the retrospective nature of the legislation. People are not going to be happy about this. Parliament does not retrospectively legislate very often, and we only do so normally with a very good reason.
Now with his party in government, the responsibility for justifying retrospective change lies on the other side of the House, albeit in a different policy area. Here's Upston again speaking on Tuesday.
I acknowledge that retrospective legislation is not standard. However, Parliament is entitled to amend legislation in light of judicial decisions, and I consider it in the public interest for policy intent to be accurately reflected in the law. To be clear, the bill confirms long-standing policy intent and operational practice. It does not create new policy or change MSD's treatment of clients in any way.
That public interest justification seemed to be compelling enough for Labour, who supported the bill at first reading. Here's Willie Jackson.
The more you earn, the less support you get. That's the fundamental rule when spending dollars on welfare. This legal ruling could or does create a double-dipping process that isn't in the best interests of everyone, and as a decision that, Mr Speaker, that when we looked at it, we thought that if we were in government, we would be looking seriously at it also.
Te Pāti Māori and the Greens, meanwhile, opposed the legislation. Green MP Ricardo Menendez-March argued that retrospectively validating unlawful conduct was not the appropriate response to the court's finding.
I think the solution here isn't so much to, once the High Court finds that MSD had effectively been acting unlawfully, to then go and say, okay, well, we'll just change the law so that it complies with the policy we've been unlawfully applying for quite a few years. I think the solution here is for the government to have a hard look at how they process ACC claims, about looking at the complexity of the systems, both welfare and ACC, that we've burden people with.
While Te Pāti Māori's Orini Kaipara was more direct in her criticism of the retrospective element.
The bill overturns High Court findings, just as the member before me said, that MSD acted unlawfully. I mean, the nerve of the minister and its government to put itself once again above the law, above legal rulings handed direct from High Court judges across the country. It applies retrospectively, validating past decisions and creating, guess what, new debts. It's creating new debts.
New Zealand's constitutional arrangements are such that Parliament is supreme. They get the final word on what the law is. Again, retrospective lawmaking is by no means illegal, but it is uncommon. So when it does appear, it tends to provoke debate about fairness, about certainty, and about whether such power is best used to correct legal inconsistencies, or whether it risks reshaping the past in ways that set off constitutional alarm bells. I te whakaronga koe ki te whare. You've been listening to The House, a program made with funding from Parliament's Office of the Clerk. Mātua.